Welcome to this BLM podcast. My name is Terry Renouf. I'm a consultant here at BLM. We're here today to discuss Lord Justice Jackson's review of civil litigation costs. And with me we have Alistair Kinley, who's our Head of Policy and Government Affairs, and also Adam Burrell, who's a partner at BLM and head of our costs team. Worth remembering that Lord Justice Jackson's terms of reference were threefold. Firstly, to develop proposals for extending the present civil recoverable costs regime to make the costs of going to court more certain, transparent and proportionate for litigants. Secondly, to consider the types and areas of litigation in which such costs should be extended and the value of claims to which such a regime should apply. And he trailed in a speech whilst he was undertaking the review that he'd be looking at a value of up to $250,000 of damages as part of his remit. And finally, the third element of his terms of reference was to report to the Lord Chief Justice and Master of the Rolls by 31st July 2017. And as Rupert Jackson is meticulous for detail, and he has done precisely that. So, as I mentioned, today Alistair Kinley is with us. He was at Lord Justice Jackson's briefing this morning at the Law Society on his report, and is going to set the scene for us. So, Alistair, is this Jackson 2 or is it the return of the wolf?
Thanks, Terry. I think this is it's a little bit of both, actually. The reference to wolf that Terry just made is Lord Wolf reforms of the very late 1990s, which probably were the first major report that recommended the use of fixed costs in civil cases, and eventually we saw fixed recoverable costs come in 2013 as a result of Lord Justice Jackson's first review in late 2009. So yes, it's unfinished business, I think, from both the Wolf reforms and the Jackson reforms, and in fact that phrase unfinished business is used in several instances through the report, and it's clear to me from reading it and from the discussion earlier this morning when Jackson presented his report that he very firmly regards this as something, the time for which has come, if it's not indeed overdue. And I think what's interesting to note, and Adam may build on this as well, is that what he suggests by way of fixed recoverable costs is very much incremental on what we've already got, as opposed to a really big bang, which would be more difficult to achieve and perhaps meet with more resistance. So just to refer back to those first Jackson reforms from 2009 when his recommendations were made, a lot of those related to success fees and additional liabilities which were removed with the Legal Aid Sentencing and Punishment of Offenders Act 2012, and later in 2013 fixed costs in personal injury cases, fixed recoverable costs, came in later that year. So we have a suite of civil justice reforms in 2013 which we've been applying for 4+ years, and are likely to be subject to a formal review by the Ministry of Justice in the next few months. And I think this supplemental report on fixed recoverable costs sits very much within that context. And there's a section in the report where Rupert Jackson recognises the importance of placing these new recommendations within that context, and he talks about the need for a coordinated approach, which I guess is just a synonym for making sure everything's joined up. So it's good to see that this takes a recognition of wider reforms elsewhere.
Thank you, Alistair. Thank you very much. Adam, it is within the terms of reference, and a remit was to consider the extension of civil fixed recoverable cost regime at the moment, and of course, as mentioned, that's been in place since 2013. What are Lord Justice Jackson's recommendations about extending the scheme?
Well, they're twofold, mainly in that there's the fast track scheme, and then there's also what's called a new intermediate band for the fixed costs. The intermediate band is a new track effectively that's going to sit in between the fast track and the multi-track, whereas the fast track proposed fixed costs is very similar to the scheme that we already have. It's worth pointing out that the data that's been supplied for this report does seem to be more varied and does seem to have come from more sources than the original report. And what's clear is that this is nothing that practitioners aren't already going to be familiar with. For example, on the fast track we've proposed costs, we've already got the same stages in place, and on the intermediate banding, they're using the phases that we'd be familiar with on multi-track budgets. This is very much a picking up what was left from the fixed costs that came from Jackson 1. For example, we've now got proposals for fixing costs for cases such as professional indemnity, housing, holiday sickness claims, and bent metal claims. So this is very much just a progression, and there isn't actually anything that's too radical or indeed surprising.
Thank you, Adam. I know you've had a chance to have a look at the two tables that Jackson includes with the fixed recoverable costs. Now, say we had a fast track case at the top end, 25,000. What sort of fixed recoverable costs are we looking in that instance? And also the range. You mentioned the intermediate costs, which is up to £100,000. What's the range of costs that we're looking for in that table?
Well, broadly speaking, for the fast track, so we're looking at the top end fast track of £25,000. Depending on which case type we're talking about, then we're looking at costs ranging from between £3,250 to just under £17,000, whereas the intermediate banding, you'd be looking at costs of up to almost £70,000 for the top end. So there's a very broad range, which perhaps reflects the fact that the banding going up to £100,000 is quite high in the first place.
And those would be for cases that go all the way through just to proceeding trial with various stages in between, I think, isn't it?
Yeah, that's right. There's a number of hoops to go through. But it's, again, I mean, I've already said this, but it's worth pointing out that the phases are all the phases and the stages that we're already familiar with, starting from pre-proceedings and then issue, and then going all the way up to the trial.
Okay, thank you, Adam. That's helpful. Alistair, as interesting as knowing what's in the extension, it's curious also to note that there are some recommendations that Lord Justice Jackson's made that certain categories should stay out, and I wonder if you could detail those for people listening to this podcast.
Yeah, absolutely. There are really, I think, four broad areas that appear to fall outside fixed costs across the fast track as recommended today, and fixed costs in this new intermediate track also as recommended today. And those four areas are noise-induced hearing loss claims, clinical negligence claims, intellectual property cases, and asbestos-related disease cases. In respect of each of those, there are really good reason why they would fall outside of this broad regime, effectively because each has a specific solution. Noise-induced hearing loss claims, there is current work being done under the auspices of the Civil Justice Council to deliver procedural and costs reform in respect of those cases alone. So let's see what that looks like, I guess is the message. Clinical negligence, there's a recommendation, a strong recommendation in the report that the Department for Health and again the Civil Justice Council should get stakeholders together to deliver an industry solution for that sector. And I think that does make sense. We've already seen the Department for Health making recommendations tentatively over the last couple of years that this sort of thing should happen. So again, that's, if you like, a carve out. Intellectual property cases, they have their own court, so they'll have their own procedure and can sit alongside this as they always have done. And in respect of asbestos related disease cases, there's a specialist list for dealing with those claims, and they do raise complex issues. So those four broad areas are and will remain outside today's recommendations. But just picking up on Adam's point, it's worth bearing in mind that Jackson says that holiday sickness cases, gastric illness on package travel, should be included in fixed costs. And that feels like a really sensible recommendation. But only 2 or 3 weeks ago, the Ministry of Justice recommended that some work should be done looking at the fixed costs for those cases. So I guess there's a little uncertainty as to whether those cases would fall within the fast track matrix that's come out this morning, or whether they again will have something a little bit different, and maybe they could end up being a fifth separate category, not completely outside of the regime, but having different fixed costs, as we expect to be the case for noise, for clinical negligence, and perhaps, as I say, in due course for holiday sickness cases.
Thank you very much, Alistair. Adam, you very much work at the coalface of costs as our head of costs, and quite a large team behind you reporting into you as well. I'd be interested, I'm sure listeners would be interested to know what do you see as the merits of this scheme, and perhaps some of the potential problems based on your experience of the fixed recoverable costs that were introduced in 2013.
Well, the first point, which I picked up on when I first read the report, was that there is nothing here that is surprising, and there's nothing here that we're not already familiar with. So in terms of implementation, I think in stark contrast to the first Jackson report, the original one, this is going to be a lot easier to implement and a lot perhaps less resistance. And that goes back to the point I made about the fact that there seems to be a lot more data and a lot more general input that the profession has had in this report compared perhaps to the first. One of the aims, of course, for fixing costs is discipline. It's prospective discipline rather than waiting for the end game and then just having a great big argument to try and reduce costs at the end. And whilst that probably will be an impact of rolling out the extension to fixed costs, we have to be mindful of potential abuse and the potential to try and get out of the bandings and to escape the fixed costs. But that's something that we are already familiar with. And there will inevitably, I'm afraid, be some snagging issues. As with any reform, any new rules, there's going to be some difficulties. One point that sprang to mind when I first read it was the fact that we've still got an issue on the stages with the current system and this system, presumably, unless they iron it out when they redraft any rules that are required, concerning the listing of matters very early on and effectively skipping a stage. That's something which has already troubled the courts and hasn't yet been put right. So broadly speaking, I would expect this to be rolled out fairly smoothly, but there will be some arguments around the edges.
Thank you, Adam, that's helpful. And I suppose we now next have to look at what happens next. Alistair, do we need legislation to bring this into effect? How long might it take before it comes into effect? And indeed, a few reports have gone into the long grass of a busy government, and I'd be curious to know your views.
Thanks, Terry. I think for me the first thing with this report is to remember that it's written by Lord Justice Jackson, and pretty much all of his first report was implemented wholesale in a package of legislation, rules and secondary legislation back in 2013. He's a guy that seems to get things done. He's delivered it on time today, and my firm suspicion and indeed expectation is that a good deal, if not all of what's in the report today, will in due course be implemented largely in full. The process for implementing it, as you asked, Terry, is actually going to be uniquely secondary legislation, which means that these reforms do not need any parliamentary time whatsoever, other than simply for the finished package to be presented to Parliament, and then after a period of time, as with most secondary legislation, it simply becomes enacted. And that's pragmatic, given that we have a government with in a minority administration at the moment, but it's also wholly in accordance with the way procedural reform and cost reform is done. It doesn't need primary legislation. It's something that the judiciary and the government can give to the Civil Procedure Rule Committee for the fine detail, and then the necessary provisions can be made in the way I described a moment ago. But as to timing and scheduling, that's a little unknown, and I think I'd go back to what I mentioned at the outset, which is the expectation that the Ministry of Justice will review the 2013 reforms. That's the Jackson reforms and the fixed costs measures, and the success fee measures that were taken then. They'll review those as a package sometime late this year, perhaps middle of next year, and I would firmly expect that one will want to review the last 4 or 5 years of experience, and then take these proposals today, which complement and build on that experience, and bring those to light as part of and as a consequence of that review. I think it would be premature to implement them over the next 6 months without having the benefit of looking at the progress. The mainstream Jackson reforms, as opposed to today's supplemental reform, which is limited to extending fixed recoverable costs. And just really a final point on implementation, I think is worth bearing in mind. It does sit within the context of wider initiatives. I've already mentioned the review of the 2013 reforms. There's also the important matter of the whiplash reforms that the government wants to take forward via the Civil Liability Bill and other measures. If those change the small claims limit for 5,000 up to 5,000 for motor and up to 2,000 for other cases, then there'll need to be some tweaks with the figures in the matrices today, and also there may need to be further tweaks as and when we get close to delivery of the online court, which Lord Justice Briggs has recommended, and work to deliver which is ongoing. So really, in summary, I think it will happen. I think it will happen as part and parcel of the review of his previous reforms. Implementation date, goodness knows, perhaps 2019, 2020.
Thank you, Alistair. As listeners will have noted, I remember the Wolf reforms, and what struck me about these reforms, these latest reforms, Lord Justice Jackson's, very much evolution and backed up by data, and that's why it feels as if they're more likely to go ahead and succeed. There's going to be a lot more work on this, consultation. Please look out for news about this on the BLM website, and also on the BLM policy blog. And if you haven't signed up for that, I recommend that you do so. All I need to do now is to thank our two contributors who summarised in large part a 135-page report in about 20 minutes. So thank you, Adam. Thank you, Alistair.